Top 10 Ways to Stay Out of Court. Today is sponsored by the Central Valley Regional HR Hotline. My name is Anna, and I'm the Digital Media and Event Strategist here at the California Employers Association. Before we get into today's training, just a couple details to go over with you if this is your first time with us. So as you see, your audio is muted for today's presentation, but there are going to be lots of opportunities to engage during today's training. If you do have any questions about the content, you can enter those into the chat box or into the Q&A box at any time. We'll do our best to address them as we go, or we'll leave some time at the end and hopefully get to your questions. I'll be here the whole time, supporting Virginia, so we'll make sure that your questions do get addressed. Handouts for this training will be dropped into the chat box shortly. So once you see a PDF icon and the little file name pop up, you can click on it and it should download locally to your drive. Again, I'll be watching the chat box. If you have any issues, accessing that PDF, just ping me in the chat and I'll be more than happy to troubleshoot that with you. And then last but not least, we will be inviting you to share your feedback at the end of today's training by participating in a brief survey. So it's only 5 questions. It takes about a minute to a minute and a half to complete. But the feedback that you share with us in that minute, we do take to heart here at CEA. We share the feedback with our partners over at the Central Valley Regional HR Hotline team. And then we collectively just make sure that we are meeting and hopefully exceeding your expectations. This is also the place where you can vote for what types of trainings that you'd like to see in the future. There is a field to say what you're most interested in. So we really encourage you to make your voice heard there. So at the end, you'll see a slide with a QR code. Once you click out of Zoom, you'll also see a window pop up. All you have to do is click opt-in. So we really invite you to participate. So with all the housekeeping done, I would really like to introduce our trainer today. We have Virginia Young, who is our HR Compliance Director. So you are in great hands, and I'll hand it over to Virginia.
Great, thanks, Anna. Welcome and thanks for spending your lunch hour with us as we talk about the top 10 ways for California employers to stay out of court. This webinar is sponsored by the Central Valley counties. They have partnered. We'd like to thank them for sponsoring this webinar. They have partnered with us, California Employers Association, to provide a no-cost HR hotline to employers in the counties listed here: Calaveras, Inyo, Kern, Madera, Merced, Mono, Stanislaus, and Tulare counties. The no-cost HR hotline allows employers in these counties access to experienced HR professionals at California Employers Association to provide them with guidance on a vast array of employment questions, from hiring to firing and everything in between, including leaves of absence, obligations for sick leave benefits, wage and hour, harassment prevention, and more. The numbers for these hotlines are up on the screen. We are CEA, we're the voice of the hotline, and we look forward to speaking with you on the hotline. We are not a law firm here at CEA, and this presentation is educational in nature only. It should not be relied on as legal advice. If you have issues that are concerning to you and your company, you should consult your attorney. Here at CEA, our goal is to provide California's peace of mind with solutions to HR questions that arise from California's complex and ever-changing employment laws. We offer our members, in addition to unlimited phone support, we offer them on-site assistance and consulting, as well as a multitude of online resources. If you are interested in membership, our website and phone number are at the bottom of this slide. What are we going to cover today? How to stay out of court is a pretty broad topic. So we're going to go over the 10 ways that employers can best shore up their HR practices so that to avoid legal problems. We're going to start with hiring, and we're going to talk a lot about firing, and we're going to talk about as well handbook policies and things you want to have in writing to set out what your practices are. We're going to talk about wage and hour, spend a fair amount of time on that, especially meal and rest breaks, and employee misclassification issues, which we'll go into in more detail. And we're going to talk about ways for employers to proactively address potential problems, especially harassment issues, before they start. Because an ounce of prevention is worth a pound of cure, they say. And I believe that. So off we are with number 10. The number 10 top way to stay out of court is to have strong hiring practices. If you spend time bringing people in, take your hire slow, right? Spend the time to make sure that you are, recruiting, interviewing, and hiring properly, and that you are bringing your employees on board with orientations that, both address compliance issues and also help your employees understand what's expected of them in the workplace. It is often tempting just to hire fast, to fill a position quickly, but there are some basic things that, employers should all do right at the beginning. You want to make sure that your new hires receive orientations to set the tone of what's expected in the workplace. You want to have your new employees review your handbook so that they know what your policies and practices are right at the beginning and aren't just scrambling to look things up as issues arise. You do want to make sure that all your employees have signed off on certain things, such as an at-will employment clause, which you can do in your handbook. There are required hiring documents, that you will need to have them acknowledge. And finally, one thing to consider in hiring is that even though it's hard, especially in this market, to bring people on, you want to set the tone for people to stay in most cases. And considering flexibility in what employees want or need from their schedules or things like that at the beginning is something to consider right from the beginning, because often that does help with bringing people on board who will be good employees who might just need a little bit more flexibility. Okay. As practical things to do when you hire, make sure that you have a job description for the position that you're hiring for. If it's an existing job description, you should review it and make sure you understand what it is that you need or expect from the employee who's going to be filling that job. You're much more likely to hire someone who is a bad fit when you hire without really having a good understanding yourself of what the job entails. So again, get those job descriptions in writing. You may have to create a new job description if it's a new position. Determine what your needs are realistically before you start the hiring process. Do you really need somebody full-time? Do you have full-time work for a person? Is it better to consider both full and part-time applicants? So get an idea of what your business needs are, because you don't want to miss out on a good candidate because they only want to work part-time. At the same time, you don't want to hire someone full-time if you really only have enough work for a part-time employee. Hire the right person. What this really means is take your time to make sure, that you're looking at the long term. It's tempting to hire fast, but you want, and this always includes, everyone who's going to take the job is going to have to certain skills or experience, or maybe even a particular license to do the job. But there could be a lot of applicants that are qualified. You want to interview multiple applicants as possible and make sure you're thinking about the long term, to hire a person who both meets the essential functions to do the job immediately and has the skills, to potentially be a long-term hire. So I guess in some, like any other kind of relationship with a work relationship, you want to do some research, don't jump into it immediately, even though, as I said, it's often tempting when you're understaffed and need to fill a position right away. The slower you can go, generally, the better. Now, what are some real problems that you need to avoid to stay out of court in the hiring process? First of all, people involved in your hiring process, anyone who's interviewing or talking to applicants, should not ask questions relating to protected classifications, either on your written application or, like I said, anyone who's talking to the person during the application process. There are a lot of protected classes, as we will see later in the presentation, but questions about a person's age or family status are definitely off limits. Questions like, what year did you graduate from high school? You know, that obviously, you know, reveals the person's age and should be avoided. You also want to completely avoid questions about a person's marital status. You know, whether questions about medical issues or previous workers' comp claims are definitely off limits during an interview. It's often, you know, best just to keep the questions work related to the job, the skills required to do the job, the person's experience relating to those skills, that kind of thing. Point number 2 to avoid when interviewing are questions about salary history. In California, employers are not allowed to inquire about an applicant's salary history, meaning what they're making in their current job or what they've previously made as compensation. It is okay to ask an applicant what their expectations are for the salary for this job, but you cannot inquire what they've made previously. And people may wonder why, you know, why do we have this law? And the purpose is to promote pay equity. Generally, women in particular have often started out at lower salaries than men. And when that is the case for an applicant and the prospective employer where they're interviewing knows what they're currently making, they just kind of get stuck. You know, they're offered a lower salary to begin with, and pay equity issues continue to grow. So the goal of this law is to kind of close the gap, you know, start all applicants on equal footing without the prospective employer knowing about any, you know, knowing that they really are in a job where they're not making very much money. So that is a law in California, not just a best practice. Make sure that you are not inquiring about prior salary history in your interviews. The same goes for criminal history. Asking an applicant about criminal history prior to making an offer of employment is not permitted in California. You can make an offer of employment that is conditional on a criminal background check, but prior to that conditional offer of employment, you cannot ask questions about criminal history. Again, focus on questions about the job, how the applicant can perform it. That will help keep you safe. That's your primary focus in your interview. It's a good idea also, when you start the interviewing process, to have an orientation checklist so that you make sure all the different people in your organization who are doing these things, who are interviewing or engaged in the hiring process, are aware of what your process is, what things need to be done, and what things, you know, things like this, interview landmines that they should avoid. Let's see. I will add with respect to salary that, you know, you should have a pay scale available for your, or you need to have a pay scale available, because an applicant who requests what the pay scale is for the position, employers are required to provide one. And employers of 15 or more in California are required to put their pay scales on their job postings. So those are important rules to keep in mind when you are planning and interviewing. Okay, so number 9, a way to stay out of court, and we're covering a really broad spectrum of issues here. So You know, you may have additional questions. Each of these issues could probably be a webinar in and of itself. So, you know, if you do have questions, you know, that's when you want to call the HR hotline, maybe sign up for a more in-depth webinar on any of these issues. CEA offers many different kinds of webinars if you need to go deeper into any of these topics. So number 9, California's many leave laws. It is very important if you have employees in California that you are aware of absences from work that are protected by law. And protected leave, protected absences means that the employee cannot be punished for missing work due to these protected reasons. California has more than 20 different laws covering protected absences from work. Each of the laws works slightly differently. Not all leave laws will apply to your business. The laws are often based on employee count. I will say that if you have 5 employees in California, you are subject to to the majority of the leave laws. So it's not just for large employers, but there is some differentiation based on the number of employees you have. Let's go a little bit deeper into one protected leave law that applies to all employers, and that is California's paid sick leave law. Paid sick leave is a statewide law that requires paid sick leave for employees. In general, the requirement is 5 days or 40 hours of sick leave each year. Employers have a number of options to structure their paid sick leave policies to provide the required leave. They can have an accrual-based policy where employees accrue paid sick leave as they work. It has to be at a rate of at least 1 hour for every 30 hours worked. When you have a policy like this where employees are accruing their paid sick leave over time, in general, you know, you have all of the time has to carry over to the next year. It's not lost at the end of the year. And it's generally, they're based on hours worked, the accrual type policies. But I think the main thing to remember is that they're generally accrued over time and the unused amounts are carried over into the next year. An alternative way of providing required sick leave in California is a lump sum policy of just giving employees 5 days or 40 hours of paid sick leave at the beginning of every year. And by 5 days and 40 hours, this means it's either the greater of 5 days or 40 hours. So if you have an employee who works 10-hour days, 5 days is 50 hours, right? Also, if you have an employee who works 2-hour days, they would still be getting the 40 hours. So hopefully that was clear, but if it wasn't, another way to put it is that if you use this lump sum approach, you're giving all of your employees at least 40 hours of paid sick leave, whether they're part-time or not. So lump sum policies, unlike accrual policies, are the unused time is emptied and reloaded every year. So a lot of employers find that attractive. But again, you know, if it's not prorated for part-time employees at all. So if you have a lot of part-time employees, you may not want to be giving them, you may not want to use a lump sum policy because you're going to be giving, you know, people who only work part-time, you know, a full 40 hours of paid sick leave. So you need to look at your, you know, look at your business, see what works best with you, accrual versus lump sum. But definitely choose one and know what kind of policy you have. As we'll talk more, you have to, later on, you have to give employees certain information about their sick leave. So it's important to have a policy. Under either type of method for sick leave, you can require new employees to wait 90 days prior to using their sick leave. This is up to you. You don't have to have this waiting period to use the sick leave. And I'm emphasizing the word use because they get the sick leave in their banks or they start to accrue it, depending on what kind of policy you have, from day one. You as an employer are allowed to set a 90-day waiting period for them to access this time. Whether you want to do that or not really depends on your business. If you have a lot of turnover, it might make sense to have a 90-day waiting period, because if you have a lot of employees who only work for a few months and move on. On the other hand, if an employee comes on in January, the odds of them needing a sick day between January and April is pretty high. And if you have a 90-day waiting period, it just makes those situations more difficult to deal with. So your choice on how to approach sick leave, but it is a pretty technical law, so you want to make sure that you have a written policy and procedures around paid sick leave. Paid sick leave is not paid out at termination. However, if you do have an accrual policy and an employee leaves and is rehired within a year, you do have to reinstate their accrued amounts, but not paid out at termination. This is different than for vacation. Vacation does have to be paid out at termination in California. So if you decide to combine your vacation and your sick leave into one paid time off or PTO bank, you need to be aware that all of that time will have to be paid out on termination, because your vacation has a lot of rules, sick leave has a lot of rules. If you mush the two together into a PTO policy, you have to comply with all of the rules for vacation and all of the rules for sick leave at the same time. So PTO is great. But it is more complicated, and it does have implications that a lot of employers don't realize. So if you're thinking about it, you want to know more, please give us a call on the hotline. We'd be happy to talk it through with you. Last point with respect to paid sick leave, please be aware that there are some localities that have their own paid sick leave ordinances that generally work with the state law, but there are some differences you may need to be aware of. Those cities are typically in the Bay Area, San Francisco, Oakland, Berkeley, Emeryville, or around Los Angeles, San Diego, Santa Monica. Not that many cities have paid sick leave ordinances, but if you do have employees in a city that has a sick leave ordinance, you want to make sure that your policies and practices comply with both the state law and the local law. Let's see. Number 8, ensure that your exempt employees are really exempt. This is one important way. Misclassification of employees as exempt is a big problem. All employees need to be classified as one or the other. They're either exempt from or non-exempt. And what exempt is referring to is the wage and hour laws. So if you misclassify someone as exempt and from the wage and hour laws and don't comply with them because you think that person is exempt, and your classification is not correct, there are some risks, for all of the wage and out relating to damages and attorney's fees, et cetera, for all of the wage and hour laws that were not being complied with during the period the person was misclassified. And this slide is just some sort of terrifying numbers for large cases where many employees were misclassified as exempt. The point is that, you have to make this decision about exempt and non-exempt with respect to every employee. And if it's an important decision, so you should make sure that you know the rules. So as I mentioned before, as the name suggests, exempt means someone is exempt from the wage and hour laws. And this sounds like a great idea because it's fewer laws to comply with. You don't have to deal with overtime, meal and rest breaks, or timekeeping because these generally don't apply to exempt employees. So it sounds like a great idea, but in order for someone to be exempt, you have to be able to show that they pass both a duties test and a salary test. There are some types of exemptions that have different kinds of salary tests. But for the most part, you're going to be looking at both a duties test, what kind of job duties are they performing, and a salary test of 2 times the minimum wage. The salary is a flat salary for the skill they bring to the job. They get the same salary whether they work 50 hours in the week or 20 hours in the week. So it's basically, you know, you're paid for the skill you bring to your job for getting the job done and not by hour. So let's talk a little bit more about these tests that are so important. Let's talk about the job duties tests. The job duties tests refer to what the employee actually does in their job. And there are three main categories of exempt white collar exemptions. These are the most commonly used. They're called the white collar exemptions, your executives, administrators, and professionals. All 3 of these have to spend at least 51% of their time on exempt duties. They all have to use discretion and independent judgment. But breaking down the 3 of them a little bit, your executives are people whose primary duty is managing 2 or more full-time employees or full-time equivalents in your business. If they are spending 51% of their time, they have to be doing things like that are management related, such as you know, interviewing, hiring, scheduling, counseling, dealing with performance issues. Those are exempt duties that they have to be spending 51% of their time on. If they are a working manager and they are spending a lot of their time doing the same thing as the people they're supervising, then you're likely going to have a problem with the duties test for your executive. Your administrator, on the other hand, is someone whose work directly relates to the management policies or general business operations of your business. Think like human resources manager, marketing manager. Your exempt administrator is not really involved in making your product or delivering the service that you're providing to employees. They're really running, you know, a functional department relating to your management or general business operations. And professionals are people who are licensed and primarily engaged in things like the law, medicine, accounting, teaching, architecture, engineering, dentistry. These are all occupations or professions that can qualify for the professional exemption. So you have to take a good look at what they're doing, and they do have to earn a certain minimum salary that we're going to talk about in a couple of slides, along with the minimum wage, because they are related. So number 7, what rules do you have to apply to your non-exempt hourly employees? It's important to know these rules, you know, because they are the source of a lot of litigation. Meal and rest breaks is probably the number 1 type of wage and hour action that we're seeing these days. And you need to be aware of how many you need to provide, how long they need to be, when they need to occur. Overtime, knowing when to pay it and what rate to pay it at is important to know. Wage statements and all the required elements of your wage statement are equally important things to be aware of for your non-exempt employees. There's a discussion at the bottom of the slide about defining your workday and your work week. Your workday and work week refer to how you calculate your overtime. They help whatever your work week is, excuse me, will allow you to determine when overtime is due for the week, and whatever your workday is will allow you to determine when overtime is required for your non-exempt employees who work more than 8 hours a day. So let's talk a little bit about about all of these important areas for your non-exempt employees. As we mentioned before, non-exempt employees are paid by the hour for the time that they work. They have to be paid for all of their hours worked. So you need to be very careful about non-exempt employees performing work off the clock. If you are allowing them to perform work, if you know or should have known that they are performing work for you, and they don't, and it doesn't get recorded and they're not paid for it, that is going to be on the employer. And that is, so you need to watch out for non-exempt employees who are performing activities, doing immediately before clocking in or clocking out. If they're performing remote work that isn't getting captured on their time cards, those are off the clock problems that you need to be aware of. Basically, anytime the employee is subject to your control, or like I said, if you know or should have known that they have been working, they need to be paid for that time. Strict timekeeping is required, clock in, clock out. And again, their meal breaks, rest breaks are also required, and we'll go into a little bit of what's required with respect to your breaks and overtime in the next slides. And finally, just in general, every employer needs to know what wage order covers their employees. Wage orders are industry specific. There are 17 wage orders in California. Most of them relate to a specific industry, such as manufacturing, the mercantile. So there are some wage orders that only relate to what the employees do, as opposed to the employer's industry. But you do need to check and see which wage order applies, and it does need to be posted in your workplace. So if you do not know where the wage orders are or what wage order applies to your company, you can find that information at the Labor Commissioner's website. That is at dir.ca.gov, and we'll try to put it in the chat before we leave today. But if you don't know your wage order, that is definitely something to figure out and have posted in your workplace. Okay, let's talk about minimum wages and minimum salaries for exemption.
Virginia.
Yeah.
Really quickly, since we are talking about exempt versus non-exempt, we did have a couple questions come up that I thought was a good time. Just a clarification on if exempt employees are required to take a meal break at a specific time. And then off of that, what if an exempt employee discloses they didn't take a meal or rest break?
Okay, so yeah, those are great questions. And we actually have a slide about meal breaks coming up in a little bit where I can answer both of them. But in general, it's non-exempt employees. You have to watch the timing and deal with the meal break periods. And we'll go into that in just a couple of slides here. So thanks for bringing that to my attention. I'll make sure I talk more about both of those two questions when we get there. So non-exempt employees, let's just take a quick look at minimum wages. Non-exempt are paid hourly. The statewide minimum wage is $16.50 an hour for all hours worked, no off the clock work. If you're exempt employees, we talked about the minimum salary that they need to earn. The minimum salary for the white collar exemptions is a multiple of the state minimum wages for the year. So basically you take the non-exempt hourly wage, multiply that by 2, and multiply that number by 2,080 hours, which is what a full-time employee works in a year. And that's how the state determines the exempt salary. So this year it is $68,640, and it rises when the minimum wage rises. So it's important it's important to be aware of the state minimum wage, both for your non-exempt employees and for your exempt employees' salaries. I will note that some industries have higher state minimum wages. There are covered employers in the fast food and healthcare industries are subject to higher minimum wages than those on this screen here. but other employers statewide, these are your numbers for 2025. Sometimes the exempt employee salary will be too high. And you may decide, I really can't have this person classified as exempt anymore. The salaries become too high. I can't afford it. Or maybe the employee wants to go part-time or not work full-time, and you don't want to pay them this full salary. It is fine to transition exempt employees back to non-exempt status. Sometimes that can be not received. Sometimes that isn't received well by an employee. They don't like the idea. So we do have some tips at this bit.ly link here on the slide to help you if you need to make that transition. We often get the question of whether this exempt salary is prorated for part-time employees, and the answer is no. If you have an employee working 2 days a week and you want them to be exempt, you still have to pay them this $68,640 annual salary. So a little bit further on minimum wage, be aware that there are over 40 local minimum wages that are higher than the state minimum wage. The local minimum wage is based on where the employee is physically working, which may be something different than your business. It may be their home or a client site. And we do track local minimum wages here at CEA at this bit.ly link at the bottom of your page. Minimum wages do not affect your local minimum wages do not affect your exempt salary. So that bit of good news. Okay, so rest breaks and meal breaks that Anna asked about earlier. So rest breaks, employers have to authorize and permit a 10-minute net rest break time for every 4 hours or major fraction thereof. This chart on the left shows you when rest breaks are required. It depends on how many hours the employee works in the day. If they only work 3.5 hours or less, they do not need a paid rest break. But if they work more than 3.5 hours, they need these 10-minute breaks as described in this chart. So rest breaks are paid time. You do not need to have your employees clock in and out for your rest breaks. They are paid time, they're hours worked. Employees have to be able to leave the premises. They may not have time to go anywhere and get back in time in 10 minutes, but that is not your problem. You just cannot restrict them from leaving during their time. Failure to provide rest breaks or insufficient rest breaks, if that occurs, then the employee is owed 1 hour of premium pay, and this is 1 hour of pay at their regular rate for the day that they missed one or more rest breaks. Meal breaks are a bit different because they are unpaid. They are 30-minute, they have to be at least 30 minutes uninterrupted, and meal breaks are required when you have an employee who works more than 5 hours a day. Employers are required to keep records of meal breaks, time in and time out. You need to have your employees clock in and out, and you cannot round their time to the nearest 5 minutes. You cannot do that with respect to meal breaks. Meal breaks have to start before the end of the 5th hour of work. So an employee who starts at 8 o'clock in the morning will need to clock out for their meal break by 12:59. 4 hours and 59 minutes into their shift, they need to be clocking out for that first meal break. Employees who work more than 10 hours in a day are entitled to 2 meal breaks. And similar to rest breaks, if your employee's meal break, your non-exempt employee's meal break, is if you don't provide one, if it's late or insufficient, that employee is also owed 1 hour of premium pay for a day in which they miss their meal breaks. Also with respect to meal breaks, employees, next slide to advance here, sorry. Okay. There we go. Employees need to be relieved of all job duties during their meal breaks and also during their rest breaks. There are very limited circumstances when an employee can have an on-duty meal period. Very limited, and we would recommend, so limited that we would recommend consulting counsel before you would implement on-duty meal breaks for employees. There are situations in which an employee can waive their meal break if the employee works no more than 6 hours in the day total, and they agree, both the employer and employee agree to waive the meal break, they can waive their meal break. The employee who is entitled to a second meal break, if they work no more than 12 hours in the day and have taken their first meal break, they can agree to waive the second one. But again, it has to be a mutual agreement. You can't require employees to waive these breaks in this situation. Overtime we talked about. Overtime is required when employees work more than 8 hours in a workday or more than 40 hours in a work week, or when they work on the 7th consecutive day in a work week. And the overtime rate increases, and the employees are required to be paid twice their regular rate of pay for hours over 12 in a workday, or if they work on that 7th day of a work week, they have to have double time for any hours over 8. Overtime is paid based on the regular rate of pay. This may be higher than their hourly rate of pay because you have to include certain types of incentive pay in your regular rate, such as commissions or non-discretionary bonuses. Things that do not have to be included in the regular rate are things like holiday pay, vacation pay, or certain purely discretionary bonuses. So be aware of those terms. Make sure you're calculating the overtime rate correctly. Oops. Okay, accurate wage statements are the other really important part for non-exempt employees. We are a bit short on time today, so I'll go through this quickly. There are a lot of things that employers have to have on their wage statements. You have to have the company's name and address, their correct one. You have to have the employee's name, the employee ID or social security number. If it's social security, only the last 4 digits. You need to include all applicable pay rates, and then as well as the number of hours and wages earned at that pay rate for the pay period. You'll need to have your pay period dates specifically listed on every wage statement. You'll need, as I mentioned, the gross amount of pay. You do need to include premium pay. Those missed meal and rest breaks also need to be on your wage statement for non-exempt employees. All the deductions must be itemized and listed, and as well as their gross and net earnings. And then finally, paid sick leave needs to be communicated to employees with every wage statement, including, how much they've used in the previous period and their balance. I know that was a lot to take in a very short period of time, but it's important to look at your wage statements and make sure that that they have all of the required information and that it's correct. Let's see, avoiding number 6, another misclassification issue is misclassifying people as independent contractors. Usually someone who's performing services for you is going to be an employee and not an independent contractor. To have an independent contractor, they have to satisfy the ABC test in California or one of its exceptions, and that is a very difficult standard to meet. Our advice is to consult counsel about any independent contractor relationship you want to enter. There's the ABC test is outlined here. I won't go into it in detail due to the time, but it is a difficult standard to meet. You do having a written contract with any independent contractor is highly recommended for anything. But in California this year, there is a new law, the Freelance Worker Protection Act, that requires a written contract meeting specific items in it for these. Currently, the services listed are the ones that the Freelance Worker Protection Act applies to, but in general, it's a best practice for any independent contractor relationship. Let's talk briefly about insurance. Having good insurance is a very important way to protect yourself. You have to have workers' compensation insurance. That's a requirement for every employer. So you need to know your carrier. You need to notify your employees of who your carrier is. And you need to know generally the process, especially when to give your employee a form. You do need to give them a form to submit a workers' comp claim if they're in the event there is a workers' comp injury or illness or work-related injury or illness. You should consider or look into employment practices liability insurance to provide you with protection in the event of claims such as harassment, wrongful termination, and wage and hour. This is not a required form of insurance, but it does provide you with protection in the event of these types of claims. Number 4, know how to prevent and correct harassment, because that is a requirement of all California employers. Harassment can occur anywhere and anytime. If it affects the workplace, it can occur at after hours events. It can occur via social media or other electronic forms of communication. So it's important that you develop a harassment prevention policy that specifically outlines your complaint process and provides how that's going to work. You cannot promise total confidentiality in investigations, but you can promise them you will keep things confidential to the best of your ability. There are specific rules about what needs to go into a harassment prevention policy in California, so you want to make sure you spend some time on that. And in general, your policy should prohibit more than just harassment. You should also encourage professionalism and respect in your workplace. As a general notion, if employees, are not encouraged to communicate, to discuss, issues of unprofessional or disrespectful conduct, that's where harassment claims tend to evolve from. So it's important to develop a thorough policy that you're familiar with. In addition, California has harassment training requirements for all employers of 5 or more employees. If you have 5 or more employees, you have to provide harassment training every 2 years to every employee. Every employee has to have an hour of training. Supervisors and managers are required to have 2 hours every 2 years. New hires and promoted supervisors need to be trained within 6 months. And there are specific requirements for training within 30 calendar days or 100 hours worked, whichever comes first, for your seasonal and temporary employees. Now, an important part of preventing harassment in the workplace is knowing when you have to investigate. And this little wheel here kind of shows you that it's not just the obvious ones. Certainly these ones on the bottom, if an employee makes a complaint, either formal or informal or anonymous, that triggers an employer's duty to investigate. Other triggers are if you observe conduct that violates your harassment policy, and certainly if you get an administrative charge or lawsuit filed, that will trigger a duty to investigate. If you haven't done so previously, you probably want to consult your counsel in the event that some charge or lawsuit has been filed. But there are other triggers for investigation. If you suspect that harassment is occurring in your policy, you should investigate that, because the standard of employer liability for harassment is when you know or should have known that harassment occurred. The standard for employer liability is even higher and is strict when it's the supervisor who's harassing a subordinate. So it's very important to be aware of what's going on in your workplace and to act when you see conduct that makes you think harassment might be occurring, when you suspect harassing behavior. Often persistent gossip and rumors in the workplace, unexplained behavior, performance, or morale of certain employees can indicate a problem. So following up on these kinds of issues, gossip and unexplained changes in behavior, these can help you identify harassment issues and prevent harm before it happens. Okay, number 3, effective discipline and documentation. Document is one of the most important things you can do to stay out of court, to make what has happened during the employment relationship with any performance problems, provide evidence of that you would need in court in the event there's a wrongful termination claim. So coaching and communication and performance, and documentation of issues, including performance issues, should start at the beginning. When issues come up, your documentation should state the problem, tell the employee what's going to happen if the issue occurs again, get their signature on it, certainly, so that they acknowledge they've received notice that their behavior was not appropriate or their performance was not acceptable. It should also, your documentation should also list ways that you're going to help the employee make improvements in their performance if that's the issue. So documentation is key. The other thing that goes along with this is to make sure that your work decisions, hiring, firing, promotions, discipline, things like that, make sure they're based on work factors. Any employment decision that is based on a protected class, and there are a lot of them, which I will show you on the next slide. Any decision that is made that based on a protected class is going to be possibly the subject of a claim in court. Similarly, well, I shouldn't say similarly, employment decisions that are based on work-related factors, such as performance, violations of company policy, those are not problematic. It's the ones that are based on protected classes or that are vague enough and not documented so that there's an argument they're based on protected classes that are going to be a problem. So what are the protected classes in California? Oops, skipped over it. Sorry. This is a list of the current protected classes under California's Fair Employment and Housing Act, and there are a lot to remember. So focusing on making employment decisions work-related only will help you avoid pitfalls, even if you don't have this list completely committed to memory, right? If it's work-related and it's documented that it's work-related, that's what you want. So how do we achieve this in our workplace? Requiring employees to focus on work during working hours, promoting civility and respect in your workplace, enforcing your harassment prevention policies, as well as your professional behavior policies in the workplace. Oftentimes, politics, discussions or differences about political views raise arguments in the workplace, and they also raise issues of harassment. And it's important to remember that harassment, verbal epithets, things like that based on national origin or gender or race are never okay, even if the person who's using these epithets, is using them because of political reasons or views, so be sure, don't let discussion of politics be a cover for what is really harassment in your workplace. Harassment and problems often occur through, by technology. You want to make sure you enforce your use of technology policies. And also, this doesn't mean eliminating conflict from your workplace. Conflict is important. It helps employees grow. It helps you get things done in find different and better solutions to problems. But there is a very clear difference between respectful, healthy conflict and harassment and unprofessional behavior that you want to make sure you monitor in your workplace. What kinds of employee discipline can we take? Certainly an employee who violates legitimate employer policies can be punished. But again, you don't want to assert your own political opinions or have have people treated differently based on different political affiliations or things like that. You want to ensure that your personnel policies are applied evenly to everyone. Interestingly, there was a law this year, no captive audience meetings. That means that employers cannot require employees to attend meetings for the employer to express their political views. So all the more important reason to keep discussion of politics out of the workplace. Okay, we're down to the top two ways, and now we're going to talk about firing fast. Hire slow, but fire fast. When you've made the decision that it's time to end your employment relationship, that should not, unless the employee has done something really egregious that mandates immediate termination, or if it's a layoff, the employee should not be surprised they're being terminated. There should have been the documentation process where they've been, bad behavior or poor performance has been identified. The opportunity to correct the behavior has been given. So it should not be a surprise to anyone. There are some things that you are required to give when you terminate an employee. They're required to be provided with unemployment insurance information in the form of this pamphlet. Are required to receive a notice of change in relationship, whether they were discharged or laid off or voluntarily quit. They're also required to receive a health insurance premium payment information form. And there are additional forms that they need to receive if you offer health insurance coverage. The COBRA forms, the COBRA election notice, and the certificate of plan coverage in the event that you offer these group benefits. So make sure you have these forms ready to go. And also make sure you have their final pay ready. If someone quits in California, with more than 72 hours notice, you have to have their final pay available their last day. If they quit with less than 72-hour notice, you only have 72 hours after notice is given to have their pay to them. And this includes weekends. It's not business days. So that can take you by surprise. Be sure you're prepared for that one. You can only mail a final paycheck to a voluntary quit if they request it in writing. On the same note, in the involuntary termination, payment is due on the last day. I like to say when the words leave your mouth, their final paycheck needs to be in your hand. And direct deposit is not recommended because that requires both a separate authorization and it requires that the final pay be there at the time that it's due under these laws, which can be very difficult to arrange. So best practices, do have a witness present at termination meetings. If it's a voluntary resignation, have them sign the form. Sorry, I'm going a few minutes over here. Thank you for hanging in there with me, and I'd be happy to stay on and answer any questions. Let's see. Best practices, we talked about the witness, voluntary resignation form, conduct an exit interview. This is not required. A lot of employers choose to have exit interviews. Some employers don't, but an exit interview can be a valuable way to get feedback from the employee. We highly recommend a termination checklist that both the employer and the employee sign off on, where the employee acknowledges that they've received all of those documents that we just talked about. And the number one best practice stems is in your employee handbook. Employee handbooks are not necessarily, they're not required, but they really help help an employer do a number of things. First, they confirm the at-will nature of employment with your employees, that there is no specified time at which you're guaranteeing employment will last. It allows you to provide you a place to set forth your required policies and notices, as well as set forth your expectations for employee performance and behavior. Your handbook can provide you a defense to harassment allegations, as well as other types of claims if you have policies in place. It sets out your benefits so that there is clear understanding and expectation from the employees of what benefits they're getting, how much vacation, what holidays, things like that. And finally, it sets a positive tone for your business that you as an employer have taken the time to think about these things and communicate them clearly to your employees. People often ask what is required versus recommended in a employee handbook. The only required written policies for you to have are the harassment prevention, lactation accommodation, policies relating to state and federal family, medical, and pregnancy leave, and paid sick leave. These are required to be in your handbook. Highly, highly recommended policies relate to meal and rest breaks, overtime and vacation. And with respect to vacation, make sure your policies do not provide for forfeiture. And because employees cannot forfeit vacation, your vacation policy should have an accrual cap on it to avoid large sums that you have to pay out at termination. Attendance policy is highly recommended. Outline what your attendance policy is, whether it's occurrence-based or more general in nature. You want to have a drug and alcohol-free workplace policy to set your expectations there. And certainly you want to have employee conduct policies specific to your business. In general, electronic communications and things like that are common to almost all businesses. But employee conduct policies, behaviors that are unacceptable in the workplace can be listed out there. Doesn't need to be an exclusive list. And takeaways today, do review your internal procedures for compliance. Make sure your supervisors and managers know what your policies are so that they are implementing your wage and hour policies correctly, your meal break policies correctly, reporting harassment when they see it. Training, it's great to have really good policies, but if your supervisors don't know how to implement them and when to recognize that they are implicated, then it doesn't do you that much good. I do have an open door policy so that employees know, feel free to reach out to someone if they feel that something isn't right or something is bothering them in the workplace. This allows you to nip problems in the bud as opposed to not knowing about them for a long time. Make sure your employees also know your policies and ensure that they are clear on them. And then finally, laws change in California every year, and it is important to update or at least consider updating your handbook at least once a year. Thank you for staying a few minutes over with me. If you are interested in CEA membership, this is information about our different levels of membership. All associates get the unlimited phone support, plus our written online materials, forms, and toolkits, and additional benefits are provided as you go up from there. We do look forward to speaking with you on the hotline one day. And for those of you who are getting certification for today's training, here are your HRCI and SHRM codes for the day. I am happy to stay on for questions if we have them. So I will ask Anna, do we have anything in the chat? I see a few.
Sorry about that. I was typing in the codes into the chat as well. I did have the one that I asked you did come from the chat. So the only things outstanding are in that Q&A.
Okay.
We do have, one was asking about alternative schedules, like nurses that work 312s and just how to distinct, do they get 60 hours or how to make the distinction between that. I do want to say though that the entire training next month on May 27th is going to go in really deep about alternative work weeks and everything that goes into there, but I will let Virginia speak to that.
Yeah, I agree. Alternative work weeks are a very technical area, and I would recommend, if you have any burning questions, I would recommend calling us on the hotline about that. But I do recommend the training next month for a deep dive into alternative work weeks and what you can do and can't do. But do call the hotline if you need that question answered earlier. We'd be happy to talk to you about it further. See, just looking in the Q&A. How do you calculate lump sum for 5 days if they work a variable schedule with no predictable pattern? That's a good question. I believe that you need to. I actually don't know if it's variable. I think. I think you should call our hotline and ask us that one. I seem to recall that you can use some kind of averaging method, but I'm not totally certain about that. So I would be happy to answer your question if you want to give us a call or give us a chance to look that up and get back to you. When is the third meal period required? I think it's every, it would be more than 5 hours. So I assume it would be more than 15 hours of work, although I don't believe the labor code addresses that specifically, a third meal period. But I would, my thought would be, it would be more than 15 hours. And do technology and auto reimbursements or allowances have to be included in the regular rate of pay? No, I do know the answer to that one, and it is no. If it is not, the regular rate is really pay for hours worked, and those things are expense reimbursements. I think that was it.
I think so as well. Thank you so much for staying extra. Thank you to those of you who stayed extra today. This is a lot of content to go through in honestly less than 60 minutes. So kudos to you, Virginia, for tackling all that for us today. I am going to, in case I think we had a few people logging on a little bit after we started, so you may have missed the handout. So I am going to drop that into the chat one more time just to make sure you have it. So it's going into the chat right now. Once you see it pop up, you can just click it to download. I did also, along with the slide with the QR code right now, I did drop the link to the chat also to share your feedback with us. So this is how you can, let us know what you'd like to see in the future. I also have a few, resources in the chat for you with our HR forms page, many of them available to everyone. If you are a CEA member, you have access to 100% of those forms in there. As well as we do have HPT, harassment prevention training, coming up, as well as workplace investigation. So all of the things that she spoke to, I was just trying to provide you with additional resources to continue your preparation for running your departments and your organizations with as much peace of mind as possible. So with that, Virginia, was there anything else that you wanted to cover?
No, that is it. That was a lot. A lot of information.
You're a true champion for getting through all of that. And thank you all for sticking with us live. And hopefully we got through all of your questions. However, I do know that you have quite a few hotline numbers that you can call. So you literally just have to find the right county that applies to you, and then call that number, and then you will have the pleasure of working with Virginia or someone else from our HR support team who are more than happy to help get you the answers that you are seeking or recommend you to the place where we can help you further. So with that, I want to say thank you again to Virginia. Thank you all for joining us live and being so engaged today, staying over, being so dedicated. And then also thank you to Valerie and the entire team behind the scenes over at the Central Valley Regional HR Hotline for sponsoring this series of events. We look forward to seeing you next month for that Alternative Work Weeks training, and enjoy the rest of your week. Thank you for sharing your lunch hour with us. Cheers.